Ciao a tutti. This is Prof Jo at Prof Jo Explains. And tonight we are really privileged to have a very special guest, Neama Rahmani, which you may have seen on other podcasts or on CNN or Fox or Court TV or BBC or anywhere you turn on your TV or look at your phone to listen to something with regard to legal issues. I should bring him in right now, and then I'll give you the rest of his biography. Okay. He is a UCLA grad, Harvard JD at 21. I thought I graduated early, but you have me beat. He's the president and co-founder of the West Coast Travel Lawyers. And you correct me if I'm wrong, personal injury and employment law primarily. Is that right?
That's right, Joe. Primarily plaintiff's work.
Plaintiff's work. Yeah, I saw that. You just, here's something near and dear to my heart. They just opened up a practice on lemon law. And if there's one thing that I think consumers would embrace, it's lemon law practice. He's got experience as a prosecutor, prosecuted human trafficking cases and complex drug cases, and he's co-host of a LA legal podcast. So, and he, as I said, and he's all over as a legal expert and a legal analyst for good reason. He is very well informed, very knowledgeable, very smart, and very articulate. So,
thank you, Joe.
Welcome.
That introduction. So glad to be on with you. Thank you for having me.
Well, thank you. I appreciate it very, very much. So tonight it's Nick Reiner, and you're right in the middle of it. You're in LA, are you not?
I'm in LA. I live and work in Los Angeles. My home is a couple miles away from the Reiner home, the scene of the crime. So I'm intimately familiar with the area and this case.
Yeah. So is there any word on the street that you can give us that hasn't been widely circulated yet about what they think occurred or the chronology of what occurred?
I mean, we've heard a lot, and I'm happy to get into some of the chronology that's been reported. I don't have a whole lot of inside information that's confirmed. Obviously, I talked to a lot of reporters here, and there has been some speculation that Rob and Michele Reiner's throats were slashed. I haven't been able to confirm that. Obviously, that would change the trajectory of the case in terms of premeditation. Obviously, very difficult to argue self-defense or anything less than second-degree murder under those circumstances. Right. But I think what has been reported, and I think what most folks have confirmed, at least the local reporters here, whether it's the argument at Conan O'Brien's Christmas party the night before, the fact that Rob and Michele were killed in their master bedroom, and then Nick fled to a hotel in Santa Monica. I think that's all pretty strong evidence so far, as well as the multiple stab wounds that were reported on the medical examiner documents.
Yeah, and I thought, given that he's so far as we know, one person and two victims, I had thought early on that in my head, the most logical progression was that he had slashed a throat and pretty much immobilized one of them in the bed. I mean, it may turn out to be something different, but that seemed to me to be the most reasonable explanation I could come up with for him being able to kill two people when he's one. So.
No question. Obviously, Nick is reportedly 32, I believe. His father, Rob, was 78. His mother, 70. And it's interesting, when they were found in the master bedroom by Nick's sister, she originally found just her father, I believe. So it's going to be interesting to see the placement of the bodies. I still think that's a very bad fact for Alan Jackson and the defense. Obviously, you go into someone's master bedroom, even when you're living in the guest house, that doesn't strike me as second-degree murder. Certainly not manslaughter or self-defense, whether perfect or imperfect self-defense. So
particularly when it's a knife, and I don't know about other people's bedrooms, but I don't keep any knives in mine. So it does suggest that he came in with the knife and didn't find it there. But you're right. We don't know. We can only, I heard one, and I don't know, again, it's all speculation, because somebody speculated that maybe he took out the hotel room first and then went to the mansion, which would make the facts even worse for the defense.
That would be much worse. Yeah. My limited understanding is there's the Christmas party, there's the argument there, lots of percipient witnesses that are going to testify to that. I mean, there's so many things that are fascinating about this case in terms of the high profile nature of the victim, but also many of the witnesses. I mean, I expect this case to likely go to trial given Alan Jackson's sort of very aggressive reputation. I can't see him pleading this case out, though, of course, you certainly never know, because I don't think the district attorney here is going to offer any type of deal. They mentioned that's possibility of the death penalty here. We haven't had an execution in California in 20 years. And I used to work with District Attorney Nathan Hochman. He's great, very fair. But I think probably that statement that this may be a death penalty case probably isn't very realistic given the political climate here in California. Obviously, Governor Gavin Newsom, he has termed out, he's issued a moratorium on the death penalty. It would really take something extraordinary, Republican appointed to statewide office here in California to lift that moratorium. I don't expect that to happen. So this is likely a first degree special circumstances case, which would be a mandatory life without the possibility of parole here.
Yeah, that's what I thought too. Do you have any idea how Alan Jackson was brought into the case? I've seen, again, speculation about whether it was the family members, or maybe in the will there was a trust set up with some sort of trustee who was reaching out, or maybe that Alan Jackson's people reached out to him. Has there been any sort of landing on one theory as compared to another?
So if we're assuming that Alan Jackson is getting paid, right, and is not doing this, for the publicity, again, I think it's likely going to be the highest profile case, certainly in recent memory hearing in California, probably the biggest since OJ. If he's getting paid, you're right, it would have to be another family member, some sort of independent trust that had nothing to do with the estate. In this case, California, like most states, does have a slayer statute. So if you kill your parents, you are deemed to have predeceased them. You're written out of any will, trust, life insurance, anything where you could be a beneficiary. So certainly, I think it would be surprising if Nick Reiner had significant financial assets when he had a pretty well-documented drug problem and he's living in his parents' guest house. Can't imagine he has access to probably the 7 figures or more that would be required to retain Jackson's services. What's interesting about Jackson, obviously, everyone knows him from the Karen Reed case, but he's also handling a pretty high-profile case here in California where an individual was driving reportedly in excess of 100 miles an hour on Pacific Coast Highway and killed 4 Pepperdine University college students. And that individual is being charged with malice murder as well. So that case has sort of been trailing the Karen Reed one. So I think Jackson's going to have to deal with that Pacific Coast Highway case first before he pivots to Reiner. I would be surprised if we go to trial anytime before 2027.
Yeah. Do you, with regard to the statutory prohibition on somebody benefiting from the murder, does that trigger before there's been a conviction?
So there's a conviction. It's presumed that the statute applies, but a probate judge can apply it even on a lower civil standard, right? You don't necessarily need a conviction. So a judge can rule by preponderance of the evidence that Nick Reiner should be forfeited any inheritance rights under the will. Now, of course, even if that happens, the surviving siblings could certainly choose to pay for his defense, right? That's right. Something that they can do. But I would really be surprised if it's Nick Reiner's money. Again, unless there's some separate trust that was set up, but even if it was something that was set up for the purpose of his life that really has nothing to do with Rob and Michele Reiner's estate, I would be surprised if it were significant in terms of the financial support that Nick would receive. Again, here's someone that has a drug problem. If your parents, the last thing you probably want is to give someone like that access to unlimited money. You probably want to maintain some sort of control.
What do you know about California's, let's say, substantial barriers to get someone involuntarily committed?
I mean, we've seen it we dealt with it a lot with Britney Spears and conservatorship, right? It can certainly happen. Obviously, it's not going to happen now because Reiner's in custody. I don't know if it's something that Rob and Michele Reiner ever intended to pursue. Again, that's something that will typically also go into probate court, and you need to argue that this person was incapable of taking care of themselves and to have them committed. The challenge I think with this case is, notwithstanding the pretty well documented drug issues, and I think we can assume, even though I'm not an expert, obviously, that Nick Reiner does have some serious mental health issues as well. There are reports of schizophrenia. I don't know if that's accurate or not, or something that was placed by the defense, who really has done a good job on the public relations side of things as well. The standard for commitment involuntarily is, here's someone that is unable to take care of himself, right? And if you're, capable enough to go to a Christmas party with your parents and have an argument with them, and then go to the gas station and buy a drink and check into a hotel, that's someone that's capable of taking care of themselves. And I know we're going to talk about insanity in California follows the Monotone test. Very similar, right? Someone, because of a mental disease or defect, they don't know the nature and consequences of their actions. They don't know right from wrong, right? I don't think that, again, in my layperson's opinion, but who's seen enough of these cases, I don't think Nick Reiner qualifies for, a conservatorship or not guilty by reason of insanity, because again, it's such a high legal hurdle.
I looked at the insanity defense, and it's dangerous for lawyers to look at something in another jurisdiction with a half hour and figure something. So I want that caveat out there. But it looked as though the insanity defense in California is an affirmative defense. In other words, the defendant has to prove it by a preponderance, which makes the defense, I think, even harder to do.
Joe, that's absolutely right. So I can talk to you about the insanity defense here in California, why it's so difficult to prove. First of all, jurors in general, they're very skeptical of this type of defense. It really only works a small percentage of the time, but procedurally, the trial is bifurcated. So you have the guilt phase first, then the burden shifts to the defense to prove that, notwithstanding the defendant being guilty of the crime, that because of that mental disease or defect, they're unable to understand the nature and consequences of their action. They're unable to know right from wrong. And it's a burden shifting statute. The burden is on the defense. It's still a preponderance standard, so slightly more likely than not. But procedurally, the bifurcation is important because imagine you're a jury, right? And you have the defense put on an affirmative defense in the guilt phase, right? They're saying this was self-defense, this was manslaughter, it wasn't him, whatever it is. And then they have to try to pivot, right? And say, oh yeah, it actually was him, but he was legally insane. You really do lose a lot of credibility with the jurors. I think the more effective way to do it, and again, this is very risky. I don't know if Alan Jackson would do this, essentially plead guilty, and then you focus all your attention on the insanity defense. We've seen this sometime in death penalty cases. I think probably Nicholas Cruz is maybe the best recent example where the defense, and this is obviously the Parkland school shooter, worst school shooting in American history, they pleaded him out to 17 counts of murder, 17 counts of attempted murder, and they went straight to the penalty phase, and they were able to save his life. I think it's very hard to argue that he's both not guilty and also insane. I know defense lawyers never like to give up that guilty verdict, especially in a potential life case. But I do think it is hard to argue both because of the bifurcation.
Do you think it's really risky here? We don't know what other evidence there might be out there. But if the evidence that's out there is what we know, and there's nothing more that comes forward, it doesn't appear that there's a case that someone else committed who did the killings. So how risky then is it to admit what the facts conclusively demonstrate?
I agree. And when you're looking at these murder cases, typically you'll see three defenses. The first is, it wasn't me. I think that's unlikely. I expect that there's a lot of evidence, blood, DNA, video surveillance that's going to come out that Nick Reiner was the killer. So that's one defense that's likely to be unsuccessful, right? But again, and Karen Reed, I think Jackson really did a good job of putting law enforcement on trial and really bringing up an alternate theory of the case in that particular case. But assuming it's Reiner, right? Then you start looking at the other possible defenses, Joe. And one is self-defense. And I think self-defense is very difficult when there's a significant age difference And like we talked about, right, this happened in the master bedroom. Unless the defense can somehow credibly argue that mom and dad, or mom or dad, had a weapon, I just don't see that defense working. So assuming now, there is a possibility in California, and this is one of those things where the jurisdiction matters. California does have an imperfect defense statute where if you genuinely but unreasonably believe you're an imminent risk of death or serious bodily injury, it does reduce murder to manslaughter. But again, I just can't see how Nick Reiner could genuinely believe that. Maybe that's when you lead into the drug use. I'm sure we're going to talk about the drug use a lot, or the mental health issues. That's one possible way they could try to argue the imperfect self-defense. It's interesting. That's what the defense in the Menendez brothers case tried to argue as well, that they genuinely believe Jose Menendez would kill Eric and Lyle Menendez if they outed him for sex abuse. I think the courts and the jurors that considered that defense rejected it because, again, it's challenging, right? Again, it's in LA. Two parents were killed, so I just want to kind of compare. But when you shoot and kill your parents while they're sitting on the couch watching TV and you reload, they're unarmed, you have a shotgun, it's hard to argue self-defense.
Well, when you go back out to the car to reload and then go in and finish off the mother, about whom you didn't have any direct evidence that she was abusing them in the trial. Yeah, it makes it really tough.
It's very hard.
My own view is the knife makes it just extremely difficult, because I can't imagine that the knife was in the bedroom when he arrived. And so if he comes in with it, then to argue any level of genuinely believed, you were in fear of imminent harm when you could just have left the house. You didn't have to enter the bedroom with the knife. It's hard for me to believe a jury would go there.
It's very hard. And whenever you get an argument and you come back with a weapon under California law, that's premeditation. That's first-degree murder. That's not manslaughter under any circumstances. There's another very high-profile case. Again, these are all LA cases, so I just want folks who maybe are true crime fans and have been following these other trials to know how the defenses were presented. This was a Nipsey Hussle case. He was a very prominent rapper here in Los Angeles. He got an argument with someone. That individual went back, got a gun, came back, and the court and the jurors ruled that's first-degree murder. That's enough time for premeditation. And I think that's the challenge the defense is going to have when you're talking about manslaughter, when you're talking about heat of passion. There really isn't when you go into someone's bedroom with a weapon. They are unarmed. It's really challenging.
Yeah.
I think the only real possibility, and this would be very conservative, we know all in any jurisdiction, right? Voluntary drug use is not a defense. So though it can be used to negate the specific intent for a specific intent crime. So it's possible that the defense may argue, this was malice murder, but because of drug use, because of mental health issues, Nick Reiner was unable to form the mens rea, the specific intent for the premeditation. That would knock first degree down to second degree, which would give Reiner the possibility of parole at some point in his life. But again, that would require the defense to really admit to everything but that premeditation.
Yeah, again, now I only looked at California law briefly, and you're there. But I thought I found that I think it might have been 2025, that California eliminated the diminished capacity defense and says that it's not admissible. Intoxication, trauma, mental illness is not admissible to negate the mens rea, but can be used in sentencing to decrease the sentence that's imposed.
So there is no official diminished capacity defense in California, but it can be used to negate the specific intent for a specific intent crime. You can always argue as a defense attorney in California that your client lacked the specific.
Right. Okay.
Now, if they really wanted to get creative, Joe, again, this would be very creative. I was thinking like outside the box, right? And again, going back to Karen Reed, they did such an effective job alleging this cover-up, right? That law enforcement killed John O'Keefe, Karen Reed's boyfriend. I was thinking, how might Alan Jackson defend this case? One very creative way to do so would be to argue involuntary intoxication, right? You have Reiner, he goes to this Christmas party and someone drugs him, right? They put something in his drink, some psychedelic like PCP or something like that. Now, again, obviously, we know that involuntary intoxication can be a defense. Obviously, you can't form criminal intent if you do
Well,
not
talk
know.
about a case that has enough publicity now. If the claim is going to be one of these high-profile actors or actresses or directors at a party drugged him, and then he went off.
Sorry, Joe. I lost audio real quickly.
Said if that's the defense, that would take the publicity level in this case to a stratosphere unknown to humankind before. Because I'm imagining no one at that party wants to come in and testify in the first place. They'd rather be anywhere else than at a trial, having to talk about what they saw. And the idea that there would be this whiff of somebody at the party might have been in part responsible would really send them, running wherever to get out of the way of the trial. Not that that would help if they're called.
I agree. The case is going to get a lot of attention because, again, there's the murders. It's here in Los Angeles. It's going to be televised like most trials here are. You have the celebrity factor. I mean, that's very real. You have folks like Conan O'Brien and Bill Hader, even other people that were friends with the Reiners may testify. Larry David, Billy Crystal. I mean, it's your who's who of Hollywood celebrities that are witnesses in this case. So, you may have that celebrity effect like we saw in the Johnny Depp Amber Heard case that got a lot of attention. I think this is probably the biggest case in Los Angeles since the OJ case because of the gruesome nature of the murders, the fact that it was their son, the celebrities. You got Alan Jackson, a celebrity lawyer. So I think there's going to be a lot of interest in this case and a lot of folks watching. I agree with you, Joe. A lot of famous witnesses on that list.
Yep. Who would be, as I say, I don't know that anybody is happy to come in and testify in a murder trial, but I'm sure celebrities and high-profile people are at the top of the list of those who would rather be somewhere else. But they may be coming, right? So I have, well, let me ask something else first. You talked about it a little, you alluded to it anyway, the impact that drug use might have on even a diagnosis that he was. I mean, that schizophrenia idea that's out there, which is coming, I think, from one particular place, and it looks like it might be maybe not that I know, but a deliberate leak of something. We don't know that it's true. But even assuming that there's been a diagnosis, the idea that the drugs may have had impact on that seems to me to make a case that's really difficult even harder if they're going to try to even maintain the insanity defense.
It's hard, and we've talked about it, that drug use. If you are voluntarily taking drugs, even if you know it's not the exact type of drug, that really negates any type of defense, and you really bear the consequences of your actions. So, obviously we know Jackson's one of the best, not just in the courtroom, but in the court of public opinion. And I'm not accusing anyone of anything, but I wouldn't be surprised if there's a whole PR battle being waged as well to try to get some sympathy, where folks can be talking about Nick Reiner's mental health to potentially sway those potential jurors out there. But again, it goes back to when we started the show, Joe. We're talking about someone who's capable and coherent enough to go to a holiday party, to talk to celebrities, to have an argument with his parents, to go back home, go into the master bedroom, and regardless of what happened, to go to a hotel in Santa Monica, clean up in the bathroom, close the shades, walk into a gas station, buy a drink. That does not strike me as someone who is legally insane. And then you add the drug use on top of it. It just seems like a very weak insanity case to me. Now, I'm sure the defense, like most great defense lawyers, will put on their experts and they're going to opine that Reiner didn't know and he was in some temporary psychosis, but I can't see jurors believing it. It's just my humble opinion with the state of the evidence so far.
Let me play you a couple of clips. I listened to, there's a podcast out there called Dopey Podcast, and it was two former drug users, one of whom then relapsed and died of an overdose. But the podcast is pretty graphic. I wouldn't recommend it to anybody listening to this, or at least I'd mention it with warnings about what you're likely to hear if you listen to it. But Nick did 4 interviews with them over a period of time, around the time that the movie came out that he had done that was loosely based on his life. And if I can indulge you, I'd like you to listen to one and then the other and get your take on how you think this impacts the ability to raise the insanity defense. So Amber, can we play the first one? This is, I'll give you some context here. He was in rehab, and he's talking about what he did because he wanted drugs and the rehab center wouldn't give him drugs. So let's listen.
Wellbutrin and cop it on the street? The way I got Wellbutrin is actually really fun. I was at Alina Lodge, and I don't know if I told this last week, but they refused to give me meds. So to prove I was crazy, because they were like, you don't need any meds.
Yeah,
and I was like
freaking
out. And I was like, you don't think I need meds? And they're like, yeah, we think you're just all up to an act here, and this is all just fake. And I said, okay. And then I went back to, the Roost. Remember the Roost?
No.
That's what they called the little barracks.
Okay.
And I was like, how do I show these motherfuckers that I'm crazy?
Yeah.
So I was like, I'll throw a rock through a window.
Yeah.
So I started and they have this thing there that they love. That little church. It's not a church really. It's like
they were building that when I was there.
It's like a meeting room that is like has these big glass windows, and they loved it, and they always were like, Mrs. Delaney was here when they built this, and I hated that whole thing. So I took a rock and I started on the path, and I was going up this hill, and my friend Peter was like, where are you going, man? And I was like, can't talk right now, just got to do this. Yeah. And I went and I threw the rock through the window, and some woman saw me, and she ratted on me, and then they put me on Wellbutrin.
And so then they discharged you with your prescription. They dropped you off at Salvation Army with your Wellbutrin?
Yeah, I had Wellbutrin there.
Yeah.
That's how I had it.
Now, I don't know what that drug is, but it clearly was a drug that he was happy getting. What would be, if you were the defense on this, how would you approach that clip? And there are more of them, believe me, on this podcast.
Joe, I would hate it. That's an admission from your murder suspect, the defendant, that he was manipulating individuals to get drugs. And I believe, but I'm not certain, but Wellbutrin might be an antipsychotic. But I mean, here's someone that knows how to feign mental health issues, right? So he's really engaging in an act of violence to get drugs. That is bad. And that's not what you want. Someone that, again, is capable and coherent enough to manipulate a rehab facility and physicians to get prescription drugs. I mean, the problem with this case is, from a optics perspective, you have Rob Reiner, who's universally beloved here in Los Angeles and Hollywood. You have Nick Reiner, who many people think is the spoiled Nepo baby who's just addicted to drugs and ungrateful that his parents aren't giving him what he wants. And it's going to be very hard to break that. They were reportedly spending tens of thousands of dollars every month on services, rehab for their son. And what is he doing? Is he trying to get better? No, he's just trying to get drugs. And ultimately, they paid the ultimate price with their lives. And by all accounts, they're, again, obviously I don't know, but by all accounts that everything's been reported, they were very loving and kind parents. And to suffer this fate, and when you have these types of statements and admissions by Nick Reiner, I think it's going to be very high legal and factual hill for the defense to climb in this case.
Yeah, I thought it was pretty damning also. The only thing that I could come up with that the defense might be able to use is it was 9 years ago. And therefore, it isn't necessarily evidence of what he recently might have done or not done. But you're clearly correct. It does show that he knows how to manipulate when he wants to.
Yeah, the defense will try to in limit out, which they'll file a motion, right? And California is 352, the equivalent of federal rule, or in some states 403, right? They would argue the probative value is far outweighed by the prejudice because, again, it is a statement that would typically come in because it's an admission by a party opponent, right? So obviously the defense, and that's what the pretrial law and motion is all about, to keep these bad facts and evidence out. So we'll see if they're successful in a case like this.
And he sounds pretty coherent. I mean, it doesn't sound as though his mind is wandering or anything else is happening. He sounds, and I will tell you that those interviews, and as I say, I'm going to give a warning to everybody again, because not only is the language pretty, yet language that YouTube would not permit, but some of the descriptions, I mean, some of it is kind of extolling the enjoyment of taking drugs. There's also some explicit, some descriptions of sex that are pretty explicit on this. And the one thing I think the defense has going for it with regard to those clips is it's a conversation and they get off on tangents. And so to be able to get the what's being said and what he's responding to together with all these digressions makes it really tough. And I think they might have a shot at, maybe stopping some of it, because they'd have to get in so much other information that is really not very attractive to the defendant in order to get to some of them. But that one I was able to pull, and there was, except for one profanity in there was nothing, but most of it is, you have to pick it out of a lot of other information that's being talked about. So let me let you listen to another one, which you may have heard, because this one I have heard other places. And this is, once the movie came out, Rob and Nick did a promo tour for the movie and they're interviewed. And this is his description of an interview that he did, or maybe more than one.
Sound like, did you like the movie, or is it? You didn't love the movie?
I feel like I didn't get to express how I truly felt in it.
Well, that was where I was. How much creative control did you have?
1/3, and 1/3 technically, and 1/8 realistically.
Okay. Well, this is the first question. It's like, the story is supposed to be, and I'm not talking about the story of the movie. I'm saying in order to promote the movie, you kind of have to be sober. You kind of have to be a poster boy for recovery, and you didn't want to be that.
I said to them, listen, I'm not in the position to do this. I'm not a quote-unquote sober guy. I'm going to have to go on to these talk shows. They say, you got to do it. They want the whole father-son angle. It just shows you how disgusting the
of course.
I mean, just the story out there. So I just went out there and I just realized, look, I'm have a voice to some degree. I'm going to say what I got to say while I'm here.
At least you didn't sell out. You know what I mean? You stuck to your guns.
Right? Yeah, I'm not going to, no. Yeah.
But you would say, you were like, I'm sober today. And you didn't you didn't want to get into the water, right?
Yeah.
I'm sure it put you in a really bad spot.
It did. It was hard.
Was it really uncomfortable?
Yeah. It was uncomfortable, but I felt like it was part of the job, part of what I had to do.
It was the job. Let me ask you a question. You don't have to answer.
No, I like where you're going.
Would you get high afterwards, after the appearance?
Yeah, I would. I'd smoke a joint on the roof of my apartment.
Let me ask you something else.
Please, he's answering the question.
And in a very hard to be this honest, but right? Should I? I mean, yeah, I would. I would not ever go on to these things coked up or anything like that. I try to be straight, use the appearance as my motivation to be straight, do as best I could on it, and then afterwards enjoy a joint. After.
Did you ever do dope after or anything like that?
That's why
you didn't shoot coke or dope this year.
No, I haven't done that in about 3 or 4 years.
There's no moderating with that. Shooting coke.
There's no moderating. That's a whole life right there.
Was your dad? Did your dad know you were getting stoned?
Yeah.
Would he get pissed?
No.
He didn't give a fuck. He's a hippie, your dad.
The reason he's a hippie. Yeah. And they're very understanding.
Well, they're happy you're doing well.
But see, me saying this, I feel first of all horrible about copping to the fact that But
do you feel horrible in front of us about it?
He feels horrible in front of the Dopey Nation.
Dopey Nation, I'm sorry. Also in front of you.
This is not the choir group, and you don't have to feel upset about it.
But I feel a little hypocritical myself.
Yes.
Okay.
I think I'm more open-minded than you are.
Because I've made this big thing
So I'm like, the only requirement to be on dopey is the desire to stop.
But Nick,
Reaction?
Yeah, so I mean, here's someone, and I think most people who are watching will differentiate, marijuana use from cocaine and other what are considered more hardcore drugs. But again, here's someone who is very open about his voluntary drug use, right? The fact that obviously he made a movie about it, about his experience, but and this is the challenge. If you do go in the direction of involuntary intoxication, it's going to open the door to all these podcasts and episodes. What do you mean? You voluntarily took drugs for years. You expect these men and women on the jury to believe that you were drugged in this one instance? So again, very, very difficult case in terms of the facts that are presented so far, in terms of the rampant drug use that is, again, well documented, admitted to. I mean, these podcasts and the facts that we talk about make any viable legal defense very challenging.
Yeah. And I will add that one of the things he says throughout those interviews is he is not a believer in complete abstinence from drugs as the way to stay sober. He says over and over again that may be what other people need, but for me, I need to take, and he's talking about, he's not talking about H or other really high level drugs. So I think he may be talking about cocaine in here, but he's saying that he needs to do that. Otherwise, the enticement to do the other things would be too strong. And therefore, for him, he believes the right way to do it is to have some level of drug use.
I don't think that's the recommended Alcoholics Anonymous, Narcotics Anonymous. I mean, they really say if you're an alcoholic, you can't be drinking at all, right? If you are a drug addict, you can't be using any drugs. So certainly not the expert, but I think there's plenty of experts who would come and testify and say that's not what you're taught, because you're an addict. You can't partake in it at all if you have a problem.
Yeah, it's hard for me to see, and maybe you're more creative about it, how he can weave his way through the comments that he's taking some lower level drug because that's right for him, and be able to explain away the number of times he relapses into something else, which suggests that his idea that that's the right way to go is at least contradicted by some episodes in his life.
They'll have to come up with something, right? And we know that insanity, I mean, we've talked about it, but in practice, how does it play out? If you're really legally insane, you think you're killing, an alien or a demon, right? I don't think that's going to apply. Or God or the dog is telling you to do something and you don't know that it's wrong. I don't think we can get there. Then you start saying, do we get to some sort of second degree murder? Do we get to some sort of manslaughter? Those would probably be pretty big wins for the defense, but they're really going to have to thread the needle here and walk a tightrope in a way that gets them out of first degree, because, again, judge is not going to have any discretion whatsoever. And, drug use, mental health, that's all mitigating factors that the judge can consider at sentencing and deciding whether to make him eligible for parole at some point in his life. But if it is a first degree conviction with those special circumstances, and by the way, the special circumstances here in California will be multiple murders, multiple victims, or a deadly weapon. I think both of those seem to apply in a case like this, plus the premeditation, of course. Then none of that's going to come into sentencing because the judge's hands will be tied, and it's going to be a life without the possibility of parole case.
Mm-hmm. Can you talk a little about, because I think some people in the chat may not know, whether, to the extent there is a insanity plea, whether the jury will know the consequences to the defendant if he's found not guilty by reason of insanity, what happens next? Because I assume they'll be worried that he's going to be out on the street again, and
Yeah, they will not know. So if he is found not guilty by reason of insanity, he will be committed to a psychiatric facility. And at some point, if he is deemed competent and not a danger to the community, he can be released. So he's going to be committed for the term of his sentence. But if he is restored to sanity, he can be released at some point in his life. That's a determination that a judge has to make. And I do believe it's also a civil standard as well. But typically, obviously, if someone, is insane to the point that they stab and kill their parents, I would be very surprised if they ever see the light of day. Something would have to dramatically change for them to be released to the public.
So just, I'm sure this will come up, so let me ask. When you say the term of the sentence in the bifurcated system, if he's found guilty of murder 2, then the term of the sentence would be what he would have been imposed for murder 2, and then you go into the insanity, the not guilty phase.
Exactly. So murder 2 here in California, it's 15 to life. Obviously, there's potential enhancements as well. Murder 1, first degree murder is 25 to life. You add those special circumstances. You do get life without the possibility of parole. But, the example in the Menendez brothers case, again, they were convicted of first degree murder. There was the potential of the death penalty. The jurors decided not to sentence them to death. So when the brothers were finally resentenced, they were resentenced to 25 to life for both Jose and for Kitty Menendez. So 50 years total. And they were eligible for parole because of California's youth offender program. You can be parole eligible after serving half your sentence because they were youthful offenders.
Mm-hmm. And so at the bifurcated trial, assuming that that's what the defense does, the judge will impose the sentence he thinks is appropriate at the first stage, and that will be the sentence that carries forward with Nick, assuming that he would then be found not guilty by reason of insanity.
So during the term of the sentence, so let's say it's, let's say it's a 25 to life or 50 to life, Nick would be committed to a facility for a sentence of 50 years to life with, again, the possibility of some point, being released if he is restored to sanity. And that's something that him and his lawyers would petition for.
Do you know if it's 25 to life and the judge, in a typical case, the judge could impose a sentence of 35 to life?
Absolutely.
But in this situation, would it simply be the statutory 25 to life that would carry over? Or could the judge in the first phase impose a more significant sentence than the statutory range? I mean, within the statutory range, but the minimum being higher.
The minimum could be higher depending on the degree and any enhancements.
Okay.
It's a pretty brutal, heinous murder. I can't imagine Nick Reiner getting anywhere near 15 years or the sentences running concurrently. I mean, this strikes me as, again, absent some serious evidence of mitigation, this strikes me as, a 50+ year type of case.
Yeah. So I've been following, Amber, have you been following what the questions that have come up in the chat? Because I've been listening. And so, okay, here's one. Can you see that?
Yes.
Okay.
I do think there is security footage. We're talking about an 8-figure house in Brentwood, California. Actually, ironically, a few blocks from where OJ lived. So absolutely, this is LA. Everyone has security cameras. I think we will see that footage. And again, a lot of evidence in this case. Nick Reiner does not strike me as a Brian Koberger type, someone who's very careful in terms of leaving evidence at the scene. So I expect there to be a significant production to the defense of electronic evidence. Now, as far as character witnesses, excuse me, character witnesses can sometimes apply in self-defense cases. Again, I don't think self-defense is gonna apply here. Basically, the prosecution has to sort of open the door to that type of evidence. I don't think they would in this particular type of case. So I don't think we're going to see a character witness. It really only applies in a very small subset of self-defense cases, not in this case. I can be obnoxious. As far as the clips, it's really up to the judge to decide whether.
I don't think that person meant you. I think that person meant Nick.
Oh, Nick. Maybe we're both LA obnoxious. Look, I mean, a lot of people don't like people from LA, whether it's lawyers or defendants. And I think that is absolutely a consideration. And we talked about it. That sort of Nepo baby, rich, spoiled kid, drug user. I just think he's not going to come across as sympathetic, especially when his father is such a sympathetic figure. He was involved in many charitable causes here locally in LA and really nationwide. So I think it's going to be very tough. Do I think the case will go to trial? I really do think it will. This is why a lot of murder cases go when there's no deal to be had, right? It's not like a Koberger case where you're going to plead guilty, you're going to take a life sentence, take the death penalty off the table. Here, District Attorney Nathan Hochman is going to ask for life. The defense isn't going to take life. So they're going to roll the dice. And let me tell you something about Hochman, the district attorney here. He's been DA for a little over a year, and his predecessor was voted out of office because a lot of people thought here locally that he was soft on crime. And there's the perception that crime has really run amok here in LA. So I can't imagine Hochman, the district attorney here, giving any type of discount or deal in one of the most heinous and gruesome murders in recent history. So because there's no deal to be made, I would be surprised if there's any type of plea. And when it comes to a plea, because it's a mandatory life case, it's not like the defense here can plead open, plead to the complaint, and ask the judge for less because the judge can't give any less than life.
Let's see.
Jurors in LA, they love celebrities. But here, the celebrity is Rob Reiner. The celebrity isn't Nick Reiner. So I think this is one of those cases where the celebrity factor helps the prosecution rather than the defense.
Oh, thanks, Nurse Kristen. Okay. Here's another one because I see another one there. Go ahead.
So what was in Nick Reiner's system? So when he was arrested as part of his booking, they'll conduct a medical evaluation. And let's remember, Reiner missed his first court appearance because of a medical issue. It could have been psychiatric, could have been physical. Now, to do a blood draw or urine, generally you require a court order or a warrant. So I don't know if something like that was done when he was arrested.
And it was many hours after the killing anyway. So, you know, the extent to which you'd find the drug in the system, I guess it depends on the drug, but I think that would be another question they'd have.
Absolutely. If Nick were found not guilty by reason of insanity, he would absolutely receive his inheritance. So under California Slayer statute, the murder has to be done intentionally and feloniously. So if something was done unintentionally, then that would make him eligible for his inheritance.
And the jury won't know that either.
They won't. You know, California just hasn't had the death penalty in quite some time. It's no surprise here that it's a liberal state. And, you know, this is one of those, you know, public policy, political considerations, you know, without getting into, you know, the pros and cons of the death penalty. Just want folks to know that the practical reality is Nick Reiner is not going to be executed. We just don't have the death penalty here. And whether you agree with it or not, I think it's important because it does affect the negotiations and the calculus in this case. Because again, it's not in Idaho. It's not one of these states where, you know, Utah, Tyler Robinson, right, in the Charlie Kirk case, you know, he's facing the death penalty for that case. Luigi Mangione in New York, in the federal case, he's facing the death penalty, but not in New York State. So it does matter because it can dramatically change the course of the case. Because if you're handling a death penalty case as a criminal defense lawyer, your number one job and your only job is to keep your client alive.
Yeah. It's an interesting public policy argument for having the death penalty, actually, to push pleas and, you know, and decrease the number of trials and not have a trial in which the likelihood of a different outcome is so low.
That's absolutely right.
Yeah.
So the question is, here in California, then the guilty plea followed by not guilty by insanity trial. So here, because it's bifurcated, you know, you do have this guilt phase. And I mean, folks that aren't used to it probably think about a death penalty case, right? You have two phases. You have, you know, the jury finds the defendant guilty or not guilty. Then you determine the appropriate sentence. In a death penalty case, the jurors are to weigh the aggravating and mitigating factors in that case. Well, here, once you decide the defendant's guilty, then the burden shifts to the defense, and they have to put on evidence of that mental disease or defect, the inability to know right from wrong, the monotony test that we talked about here in California. So The reason I talk about the bifurcation is it's hard to do both because, again, you do lose credibility with the jurors if you really put on a strong affirmative defense and then you argue, hey, you didn't buy the self-defense or you didn't buy the manslaughter or the second-degree murder. Now we want you to find him legally insane. It's tough. And I think there's a very healthy skepticism of these types of cases, which is why I think it's challenging to present it both on the facts and the merits and how you handle that first part of the trial. It's going to be hard to find jurors in this because everyone knows about the Reiner case. I mean, I'm sitting here in my office in downtown about a little over a mile from the courthouse. So this is going to be one of those cases, Joe. It's going to be a complete zoo. I mean, everyone will have heard about this case. There's going to be lots more facts that come out in 2026.
Do you drive to work?
I do.
Do you have a parking space in the building?
I do.
That would be what I would worry about. I wouldn't be able to park for the whole time the trial is on.
Yeah, no, it's gonna be very, very busy here in downtown LA. So there's no, at least in California, there's no guilty by reason of insanity. You're either guilty or not guilty. And then if you are found guilty, you can be not guilty by reason of insanity. There's no guilty by reason of insanity here. There's no diminished capacity, which means that you're guilty, but a lesser degree of guilt.
I don't know whether there are jurisdictions that still do it, but for a time, there were a few states that went to a guilty but insane.
Yes.
But I don't know because some of them have moved back from that and I haven't looked. But that would be, but not in California.
Not in California. I'm sure they're going to point the finger at the doctors and the meds. You know, the best defense is always a good offense, right? So you'll see, for instance, defense lawyers put law enforcement on trial. That's a pretty good tactic. If you can put the doctors on trial as well, instead of say some combination of drugs that caused him to do it, certainly a possibility. Again, challenging given that he does appear to be so lucid and coherent in the many interviews that he's done. Possible, but I think it's going to be very unlikely that that defense will be successful.
Amber, that question came up already.
Oh, I think it's going to be live streamed on every channel, YouTube, Court TV, Law and Crime, you know, local channels here. I mean, this is California. One of the great things about this state is we believe in fair and open trials. You don't get that in other parts of the country. That's why I love living here. This will absolutely be live streamed. I would be surprised if for some reason it were not.
Same jury going to hear assuming that they go with the insanity defense, same jury for both?
Yes, it would be the same jury that hears both parts of the case. Okay. So jail here in California is when you're sentenced to a term of 1 year or less. A state prison is more than a year. This would obviously be a state prison type case. And in jail, it doesn't matter whether it's jail or prison or state or federal, you can get drug and mental health treatment. There's different programs. For instance, Sean Diddy Combs is participating in one, likely the RDAP program. So there's different programs, and certainly someone like Nick Reiner, if he is in prison, would likely participate in those types of programs because, frankly, it seems like he needs it. The defense strategy in this case is really tough. I think the most conservative strategy would be to try to get that first-degree murder down to second-degree or murder two, as Professor Jo was saying. The more aggressive strategy would be to go for the home run, whether it's the insanity, whether it's the self-defense, whether it's the involuntary intoxication. That gets your client a walk entirely. Obviously, I need to see more of the evidence, but for me, if the defense is able to get Nick Reiner the possibility of parole at some point in his life, given what we know now, I think that would be a win for the defense.
Any other questions? So here's a question for you. And I think it's a little, I know it's difficult because we don't know what the evidence will be, but if you had to give a ballpark estimate now on what you know, how long do you think this trial will last?
I think the trial will last weeks, just in terms of jury selection. Obviously, there's going to be a lot of people that have preconceived views of this case. Jury selection tends to go longer here in California State Court. Judges do allow a lot of attorney voir dire. They don't allow it in the federal system or some other states, or to the extent that they do, it's much more limited. And, you know, there's just a lot of evidence to go to in terms of the forensics, in terms of the science. Obviously, if you're talking about mental state, health, disease, or defect, this is the type of trial I would expect to last weeks. If I had to ballpark it, I'd probably say somewhere between 2 to 4 weeks, just my guess, given how these cases typically go. And look, I wish courts were efficient and this was the only matter on calendar, but sometimes they'll have to deal with matters outside the presence of the jurors and different law and motion issues. So, I would set aside potentially up to a month for a trial like this.
Okay. Any more questions? Because Neama has other commitments. He's a busy guy and a person that a lot of people want time from. Ending in a preposition. Sorry, I didn't in a preposition. Bad English, but you get the sense.
Well, thank you so much, Professor Jo, for having me.
Well, thank you for coming. God, I'm sure the people in the chat were just thrilled at your expertise and your ability to communicate in ways that I think, people who are not law trained can follow. It was just great.
Well, I appreciate you. I'm your local guy here on the ground here in Los Angeles, so I'm sure we're going to be talking a lot more about this case as more and more evidence comes out.
Oh, I'm a New Yorker, Italian, so pushy is in my DNA. So I will definitely be back. Thanks so much.
Thanks, everyone.
Okay. And we'll stay on if there are any other questions or comments that any of you want to make, I'll stay on for a little. Yeah, he's really great. And he's a California lawyer. So, there are some lawyers who are really well-versed in the law and have a lot of trial experience and can communicate very well. But when you have all that and you have someone who's got boots on the ground in the sense that this is the place where he practices, it's a real home run because he doesn't have to guess what the law is or how the practice goes or how juries are likely to act because he's there doing it. So it really, it makes it gives a plus factor that's really, really terrific. And I'm really grateful that he was able to spend the time with us. What's funding the defense? Somebody's funding the defense. And the best guess we have is it's coming out of either an independent trust or the family. Because the state isn't doing it. So it's got to come. And I don't know, Gossip, if you were there for Neama's, thank you, My Father's Alibi. That's really kind of you. I don't know whether you were at the beginning when we talked about this, but you can't benefit from a crime. So if you murder somebody, you can't inherit. And I asked how that applies before there's been a conviction. And he said he thought that probate law in California would mean that they could stop the money being used to fund the defense. But the family members can pay for it. There may be an independent trust that the Reiner set up for Nick with a trustee who can then make decisions on his behalf. I think I heard, and I don't want to misquote Josh Ritter, but I think I heard him say that because he's also local to California, that he had heard that some lawyers were being approached about their willingness to take on a case like this. And he was guessing that maybe that's how Alan Jackson had his first contact with it. It doesn't answer how it's being paid. Nick doesn't have any money unless he's got an independent money coming from Carl Reiner to him. But that doesn't appear to be true because he was living in the guest house and the Reiners were giving him a monthly allowance. And I don't remember, it was a hefty amount of a monthly allowance. And I remember thinking, he's somebody who's prone to taking drugs. You're paying his living expenses. Why are you giving him extra money to do anything at all? But I guess I'm not as kind a parent. Okay. If I were defending a case, would I plead guilty and go for NGI? Yeah, you heard Neama say the same thing. Unless there's evidence we don't know about right now, unless they're going to be able to make some claim that some of the evidence they have was unconstitutionally seized, unless something like that is going on, what we see is there was one perpetrator and it was Nick. So he's not going to be able to say it could have been somebody else, anybody but me. That doesn't seem to be a defense that's out there. The next thing would be to give the defense would have to say he's got a reason that either minimizes his culpability or eliminates it. Now, self-defense would eliminate it because you say, I only did it because I defend myself. That one seems to be impossible, given what we know of Rob Reiner and Michele Reiner. And also, for me, the fact that they were killed with a knife. Because, as I said earlier, I cannot imagine that the Reiners kept a knife in their night table in their bedroom. And so that being true, Nick had to enter with a knife, and it's pretty hard to make a self-defense claim when you affirmatively go into a room with a knife, because at best you're putting yourself in a position that you think might be dangerous. Otherwise, why are you carrying the knife? And you don't have to put yourself in that position. You're not entitled to claim self-defense after you stick yourself in the position and provoke it and then say, oh my God, then I had to do something. That defense is not available there. So, it looks like the insanity defense is the only thing he seems to have. And I don't know how arguing anything different at the guilt part of it would help. Does he still have Alan Jackson as an attorney? So far as I know, he's got Alan Jackson as an attorney. Yeah. Jackson doesn't look happy there either. Other questions? Yeah, I thought he was a great guest too. Very, very knowledgeable, very, very clear. And he knows California, which makes him just great. So I'll wait a second to see. Okay. So Animals Over Human predicts it won't go to trial and that the DA allows him to be declared insane. Well, we'll see. I guess I would disagree, but time will tell. One of us will be right. Why did this happen? Crime and punishment? I mean, I don't know. Why does any crime happen? Why does evil happen? Why do parents kill their children? That I have no answer. Okay. Sanders 14, what are the chances that the defense will opt into speedy trial to keep a lid on evidence leaking? I assume the defense could do that, but if this is a complicated case, to get the expert witnesses to review the evidence, I cannot imagine that the defense would say we want to go quickly to stop it, because the evidence we've seen already is pretty compelling. And it seems to me what they need is some time to see if they can counter some of it, not rush to get done. Okay. Jennifer and Tally says in Florida, there's a prison for those that are guilty and mentally ill. Is that true in other states? It might be. It's certainly not true in all states, but it might be. Some prisons have sections of the prison for those who are mentally disturbed. It doesn't actually have to be somebody who's been convicted or been acquitted by reason of insanity, but it can be people who have severe mental disturbances and are dangerous because of it, and they may be segregated. So I didn't talk about, if there was time, I was going to talk to Neama a little about the jurisdiction issue. No, I take it back. I'm thinking of another case. Okay. Yashuda Devi, 2008. If I don't have that right, and I'm pretty sure I don't, give me an idea phonetically how to pronounce it. What if they claim that he was locked up due to his weird behavior at the party, got paranoid due to it, and attacked to break free? Well, we have no evidence. You can't just make claims. We have no evidence that occurred at all. I mean, if there's some evidence there that that's what happened, and then what? He broke free, grabbed a knife, and killed them? It's, you still have to get past what happened next. And paranoid, the insanity defense requires that you show that you did not know the nature and quality of your act. You didn't know what you were doing, in other words. You did not know it was wrong. And in California, you have to prove that. It's not up to the prosecutor to prove it. You've got to prove that it was more likely than not true that you didn't know what you were doing, you didn't know it was wrong. And as Neama gave you some list of the things you have to get over, if you don't know what's wrong, then why are you cleaning up afterwards? If you don't know what's wrong, why do you run away? Why don't you just stay in the room or call somebody because you don't know what's wrong? If you don't know it's wrong, why do you have a hotel room downtown? Why don't you just go back to the guest house? Those are the things you have to confront on the evidence if you're going to show that this defendant did not know it was wrong, which is why the defense is difficult in any case and seems to me to be extraordinarily difficult in this one. You heard Neama, since the death penalty is not being, is really effectively not used in California, there's no plea that the state can give, because it can't practically cannot take the death penalty off the table, since everybody knows the death penalty is not going to be imposed anyway. Even if it's imposed, there's a moratorium, it's not going to happen. Then you just go to trial. So it's, it's a pretty expensive way. As a public policy question, it seems to me to be, tricky. It may be the best you can do if you're opposed to the death penalty, but it does have all these unexpected, at the front end, consequences to it, certainly in terms of cost to the people of the state. Because if the death penalty could be removed and he pled out to life without possibility of parole, you'd save a lot of time, effort, resources. You'd also save the impact on the family and all of that. Okay. Bobby Jean 8858 says these last two cases Alan Jackson has taken on seem like tough to prove innocence. You heard him when somebody in the chat asked about innocent by reason of insanity, and he said not guilty by reason of insanity, and there was a reason for that. Criminal trials do not, the question in a criminal trial is never, is a defendant innocent. The question in a criminal trial is, has the state proved its case to the burden that it has, which in the criminal case is beyond a reasonable doubt. That's why in the OJ case, he could be acquitted in the criminal trial, and then when the family of one of the victims sues him civilly, he can be found civilly responsible for the killing. Different burden. So innocent is never anything that happens in a criminal trial. What happens in a criminal trial is the defendant not guilty? And that means, did the state prove guilt beyond a reasonable doubt? You can say, I'm pretty sure it happened. If you're pretty sure it happened, then you're not saying the defendant is innocent. If you say, I'm pretty sure it happened, but I didn't get to proof beyond a reasonable doubt, you're saying not guilty because the state didn't meet its burden. I hope I made that clear. Okay. Leisharp. Did he not waive his right to a speedy trial at the first arraignment? I don't know that he did. I think they postponed the preliminary hearing. I think that's all that occurred. And you don't irrevocably waive. You can decide at a different point to say, now I'm going to, now I say I want this trial to go and assert the right. It's not, I don't think anywhere it's in, it's a one time and then you're done. Okay. Other questions? You want me in that? Well, it's after January 6th, if somebody reminds me, true crime in a minute, and that Leslie B., I will put it on. I don't look good in baseball caps. I look better in those, those newsy hats that are a little fluffier. Those are really cute. So since I don't see any more substantive questions, let me end with a couple of things. And that is, please like and subscribe. Neither of those cost you anything, and they help my algorithm, whatever the algorithm is. And I've said before, I have no idea how it works, but I am told that hitting subscribe helps it. And so if you would, that would be great. Being a member costs something. It would be great if you did that too, but like and subscribe doesn't cost you anything except hitting a button. So I'd appreciate it. Friday at 5 o'clock, I'm going to be doing my regular live, and I'm not sure yet whether I will do Charlie Adelson's appeal, which I think doesn't have much merit to it, or maybe Charlie and Donna together because they have some issues in common. And as Charlie's appeal goes, part of Donna's case will go also. Or I might do a little more on this, on Nick Reiner. And go in a little more thoroughly into the insanity defense and how it works. and some of the facts of this case. I may do it or I may wait a little on it. Then on Saturday at 3, True Crime in a Minute with Will and I will do a joint stream. So, and her channel is really great. She does some really creative things in terms of not only what she finds and brings, but even the way she does the graphics is really great. So if you're around on Saturday at 3, we're going to be doing that. And then Sunday at 6, I will be doing a members only and we'll be talking about what that will be later in the week. So that's everything for me. I am not going to sing another Christmas song because we're past Christmas, but I thought I would read you from the complete works of Shakespeare in 3 panels. You might call it very short Shakespeare. And I'm going to read you Macbeth. And I assume most of you in high school had to read Macbeth. He's the king. He's not the king who wants to be king. Lady Macbeth eggs him on. He kills the king. Duncan, the witches tell him, yeah, this is not going to go well for you. And that's what the play is about. So here's Macbeth in 3 panels. 3 witches tell Macbeth that he will become king. Panel 1. Macbeth kills lots of people in order to be king. Panel 2. Macbeth is killed. Panel 3. So now you don't have to read the play or go see the play because you know everything about the play. So ciao a tutti. It's been fun doing this, and I'm glad you enjoyed Neama. I thought he was really terrific to listen to and interact with. And I will see you hopefully on Friday or Saturday or Sunday or all 3 times. And if I don't see you until Friday, and I won't see you till Friday, Happy New Year. And Vicki Hutchins, thank you so much, Hutchinson, for becoming a YouTube member. I appreciate it. And I put on the channel a comment from me that I really have been so appreciative. It's only been about a month since I launched, and the number of people who have subscribed or who have commented or send likes or have become members has just been really humbling. So I will end 2025 with you by saying thank you, thank you, thank you. Ciao.